Test 1. Ooh, it's a little quiet. Testing 2. Testing 3. Testing 4. Testing 5. Testing 6. And testing 7.
You can be seated. Matter before the court is Androscoggin 2576, Catherine Dudley versus Hudson Specialty Insurance Company. Counsel are present. I'm assuming you're ready to proceed. We are being streamed both by audio and by video. If counsel would introduce yourselves by saying your names for the record, starting with the party you represent.
Yes, Your Honor. Anthony Ferguson for the appellant, Catherine Dudley.
Thank you, Chief Justice. Christian Henriksen on behalf of the appellee Hudson Specialty Insurance Company.
Thank you. Attorney Ferguson, if you're ready to proceed, we'd be happy to hear your argument.
Yes, thank you, Your Honor. May it please the court. The central question presented by this appeal is whether the Hudson Specialty Insurance Company liability policy renewed by operation of law because of the failure to send written notice of non-renewal to the insureds. And it's our contention that yes, it does renew by operation of the Maine Insurance Code because of that failure to provide written notice. The facts of this case concerning non-renewal of the policy largely are not disputed. The only disputed facts concern a phone call between the insurance producer and the insureds, which largely is not relevant to the issues presented to the Superior Court on the cross-summary judgment motions. What is material and what is undisputed is the fact that on July 31, 2018, New England Excess, I forget what the last D stands for, sent a proposal for possible, and I emphasize for possible renewal of the Hudson insurance policy. It's admitted that that proposal included the completion of a number of forms by the insureds, including a brand new insurance application. It's admitted that the proposal was never submitted to the insureds. It's admitted that the forms and the application that they were to complete in order to continue their insurance was never sent to the insureds. And critically, it's also conceded that the required notice of non-renewal was never submitted to the insureds. And it's our contention that the admitted failure to not send a written notice of non-renewal directly to the insureds is dispositive of this appeal. The Maine Insurance Code is a consumer protection code designed to prevent unintended lapses of insurance. The plain language of the code defines non-renewal as termination of a policy at its expiration date. We checked that box. That's what happened here. The Hudson policy terminated at its expiration date. The Maine Insurance Code plainly plainly states that non-renewal requires written notice to the insured. We checked that box too because written notice was never provided to the insured. That's it is our position. That's the end of the inquiry. That's what this court's holding was in Corinth Pellets. That's what the federal court's holding was in the Skilkins case.
I see that the green light is on. I'm going to rephrase this and see if I can make sure that I understand. Is regardless of what the conversation was between the insureds and the shampoo agency, regardless of whether Hudson is surplus lines or not, regardless of how we characterize the offer to renew, none of that matters, that your position is that because they didn't send written notice of the non-renewal,
Yes.
in other words, that in any situation, the insurance company must send written notice of the non-renewal if it's going to lapse at the end of the policy period, or cancellation if it's an early termination, regardless of all of these other things. And they didn't do that, and that fact is undisputed, and that's that.
That's correct, Your Honor.
And it must be sent directly to the insured.
Yes. That's what the Corinth Pellets case has.
And in this case, there wasn't one sent in a timely fashion to the agency in any event, was there? I thought it wasn't sent at all.
Not sent at all.
Okay.
The only possible notice of non-renewal is the notice sent by the insurance producer the day that the policy, at the end of the term of the policy. But the injury to my client happened within the time, 30 days or 14 days that they were.
And we don't have to decide that because it doesn't matter whether it's a 30-day or a 14-day.
Correct.
So what happens if an insurer contacts an insurer directly and
Yes.
said, okay, your policy's going to terminate on May 31st, but if you want, we will renew it, although it's going to cost a little bit more. Do you want to do that? And the insurer says, no, don't want to do that. What happens then?
Is this an oral communication?
What's that?
Is this an oral
Well,
communication?
let's say it's a written communication.
Well, I guess it depends on exactly what the writing says, because in
Let's say
this,
the writing says, as you know, the termination date of your policy is May 31st,
yeah,
and we will renew it at a new rate of $400 a year. Do you want to do that? And the person insured writes back and says, no, I don't want to do that. What happens?
I think a written notice of non-renewal is still required.
Okay.
I guess I'd point out in the
Unless
court,
it could be interpreted perhaps in those circumstances as, and if you don't want to do that, we will not renew.
I suppose. I think it's an easy issue to, if I didn't say this, I guess I want to point out in the Skilkins case, there was a letter from the insurer to the insured that indicated your policy is coming up for renewal, and if you want to renew it, you got to fill out an application.
But I think your point is the 2009-A notice is required in every case where there is a policy in
Yeah.
order to have it terminate on its date without the penalty.
Yes, and it has to be in writing, because as you know, in Corinth Pellets, there was oral communication, your policy's terminating. But that,
I just wanted to get from you whether
Okay.
there's any wiggle room here. You say, no, you need.
no, there isn't.
And can you just take me through what in the language of this, you've said this statute is plain.
Yes.
I assume you're relying on 2908 subsection D, non-renewal means termination of a policy at its expiration date. Is your argument that because there's no reference in there to the insurance company, we don't need sort of affirmative action by the insurance company to non-renew? Is that the argument? Maybe that wasn't a great
Yeah,
question. but-
Maybe it's because I don't quite understand.
So Hudson is arguing that renewal and non-renewal are sort of mutually exclusive, and that because there was no affirmative decision by the company in this case not to renew, but instead the policy expired by its terms,
Yeah.
they didn't have to do anything, that there was,
Well, the Corinth Pellets insurance policy expired by its terms, and this court held you have to give written notice of non-renewal. I guess I dispute that there was an offer to renew in this particular case.
but let's assume there was. Your argument is still that there needs to be a written notice.
Yes. I guess, as I point out again, the insurance code is a consumer protection code. It's designed to present these kinds of issues. So if there's notice of cancellation, the code requires that it be in writing. If it's notice of non-renewal, the code requires that be in writing, even though with respect to surplus lines, the word written is not in that particular section, but this court indicated that it did have to be in writing. Notice of increase in premiums has to be in writing. It's our contention that the notice of renewal, or the offer to renew, should also be in writing in order to prevent these.
How does the notice operate for consumer protection?
How does the notice operate?
You said this is a consumer protection law.
Yes, this court has said it is. Yes.
And, yeah, we have indeed. And just for the record, the notice required under 2009-A, the notice, how is that a consumer protection provision? How does that operate to protect the consumer?
It protects the consumer by the consumer having available this written notice that they can read and reread and try to understand, as opposed.
But they already knew that it was going to terminate on May 31st, right? That's the term of the policy.
Well,
So how does getting the notice protect them?
well,
In this case, September 14th
yeah,
or whatever
well,
it was, right?
it's a reminder that the term is coming up. The insured doesn't necessarily know that. You know, in this particular case, it was being paid monthly by a charge on a credit card. It just puts it front and center for them.
Basically, do it now or it's gone, as opposed to getting
Yeah.
an offer
Yeah.
that, you know, several months in advance.
But the bottom line is it's a reminder.
Yes.
It would prevent the type of confusion that we have in this case, right?
Absolutely. And I guess I'd like to push back that an offer to renew was ever made.
Why not?
Because it was contingent. It was an invitation to apply for.
But wasn't it on the same terms, same duration, same cost?
Or actually, your client probably doesn't know because you never actually got it.
First of all, the client never saw it.
Okay.
Second of all, the fact that they're making them reapply means that there's the possibility it's not going to get accepted. In fact, Accord 125 says the credit check on you may result in us not be willing to offer you insurance. If it's an offer, you can accept it. The insurers in this case couldn't say, we accept your offer to reinsure us for a year, because they had to fill out all of these forms.
It was really an invitation
It's an invitation to apply again.
So all these cases seem to have the accident happen days after.
Yeah, but-
Let's say it's a 3-year term, it's 2 years and 11 months.
Yeah,
The insured hasn't paid
I
on the
understand.
policy for almost 3 years. Is that fair to the insurance company?
I don't know, but that's not this case. Corinth.
One assumes the insurance company isn't going to just sit on it for 3 years.
Can I ask you a hypothetical in the 20 seconds remaining? Take a case where during discovery it's determined that the insured, I knew it was going to terminate on September 31st, and I didn't do anything about it. Would that change the calculus at all, or do they still have to do
The plain language of the statute is you have to have a written notice of non-renewal. And I think it was easily done. I have professional liability insurance. I have to reapply every year. Every year, about 90 days before my insurance expires, I get a letter from the insurance company that basically says this policy doesn't automatically renew. We have to give you notice under Maine law that it's not going to renew. However, you can reapply, and here's the link to go fill out the application.
Thank you, counsel.
Okay, thank you.
Attorney Hendrickson.
May it please the court, I'm Christian Hendrickson, representing the appellee, Hudson Specialty Insurance Company. The heart of our argument is that Hudson did make an offer to renew the relevant insurance policy in this case. Under Maine law, there are 3 ways in which an insurance policy terminates. The first is when an insurance company decides not to renew that policy. The second is when an when an insurer decides to cancel that policy. Those are distinguished because if the insurer decides not to renew, the policy expires by its terms, and if the insurer decides to cancel, it expires before the expiration date. Now, the third way an insurance policy terminates in Maine is if the insured decides not to renew. That is the situation in this case. Because the offer to renew was not acted upon, there was no coverage at the time of Ms. Dudley's accident. Because there was no coverage in this case, plaintiff's reach and apply claim and plaintiff's breach of contract claim fail as a matter of law. Maine statutory law defines what it is for an insurer to offer to renew. All of that criteria was met in this case. A quote from New England Excess Exchange on behalf of Hudson was sent to the insured's insurance agent. It literally quite says, this is a renewal quote. The policy offered was on the same forms. It was the same coverage amount. It was the same premium. And it actually says on the forms, if coverage is requested bound, this becomes a binding contract. The insureds in this case did not act upon that offer. There was no coverage after the expiration of the policy because the insureds never paid a premium. To extend coverage past the date of expiration is an undeserved windfall for insureds and a harsh result for insurers. Also, it is illogical to suggest that an insurer needs to send notice to an insured to alert that insured of its own decision not to renew. That is not what Maine statutory law obligates insurers to do, and Hudson was not under an obligation to do that in this case. For these reasons, and the reasons in Hudson's brief, Your Honors, we ask that this court affirm Judge Archer's order granting Hudson's motion for summary judgment and denying the
Counsel,
plaintiff's
I see that the
motion
green
for
light
summary
is
judgment.
on. You've said there's an undeserved windfall to the insured in such an instance. You agree, let's assume there had not been this offer that you're contending was made in July, and no notice was ever sent, okay? Everything else is the same, but you hadn't made that offer. And then there's a loss a week later. The insured hasn't, I mean, it's the same situation, but doesn't the statute clearly require that a notice be sent in that instance? And how is that different in terms of your windfall argument?
If I understand your question, Chief Justice,
And you may not, because it wasn't all that clear.
there is, Maine statute requires that an offer to renew be sent 30 days or more before the expiration. That was done in this case. So I guess if you could clarify your question.
Well, let's assume the insurance company hadn't done anything in July and then also did not send a notice of non-renewal. The insured doesn't pay a premium because they are assuming that it expired. And then there's a loss, a month later, whatever. Do you agree that under Corinth, in that situation, that policy would still be in effect?
No, and this is the key with all the case law cited by the appellant, including Corneth. Those cases all involve decisions not to renew or cancel. That is the key distinguishing characteristic. Corneth is helpful for the reason that Judge Archer cited it in her decision.
So you're saying that in that situation that there would not be coverage when the loss happened a couple of weeks after the normal policy term, it would just renew automatically and there wouldn't be a windfall? What if the insured had said, I don't want to renew?
If, under your hypothetical, Chief Justice, are you saying that the insurer decided not to renew?
Let's say the insured said to the insurer, I don't want to renew.
Mm-hmm.
And no notice is sent of non-renewal or cancellation.
Yes.
Is that policy still in effect 2 weeks after the normal termination date?
No, in that instance, I don't believe it is, and I think that goes to basic contract law.
But what about the statute,
You
which
don't need
says
to
when you're not renewing it, when the insurance company is not renewing it, you have to send written notice?
Well, the only statute that I'm aware of that's applicable in this case is the offer to renew which was complied with. But to go back to your question,
You're saying that, let me follow up on that, that 2009A1 is just not applicable?
no, it is applicable. But to go back to what I was going to say previously about Judge Archer, in her insightful decision, the only reason she referenced Corneth in her case is to make the point that the surplus line statutory law in Maine does not provide its own separate definition of offer to renew. So she takes, and she referenced that this court actually took the 2908 definition of offer renew from that section and applied it to surplus lines. That is the only applicability of Corneth to this case, and I think Judge Archer thoughtfully
Counsel,
referenced that.
can you help me a little bit with interpretation of the statute? As I understand it, you're arguing that the notice requirement only applies if the insurer makes an affirmative decision to cancel or an affirmative decision not to renew the policy. Where do you get that from the statute?
And I would add, or not act on it at all. It's not referenced specifically in the statute. More importantly, though, I would say that there's no sources that support the argument that any conditions that were imposed on the offer by Hudson in this case would disqualify it as a renewal offer.
But where does it say that an offer to renew relieves the insurance company from its obligation to notify the insurer if the policy is not ultimately going to be renewed?
It doesn't say that, Your Honor, and I think, again, it goes back to basic contract law. If someone decides not to accept an offer or act on an offer, the offeror doesn't need to alert the
Right, but we're interpreting
individual.
a statute here that has a very clear notice requirement, it's cancellation and non-renewal. So I'm still struggling with, I understand your argument that there was an offer to renew. Let's assume that it met the statutory obligation of an offer to renew. Where in the statute does it say that means the insurance, or how do I interpret the statute to conclude, well, that means the insurance company doesn't have to send notice?
You won't find it in the statute, Your Honor, and as Judge Archer stated, this court hasn't grappled with that question before. She highlighted Texas Specialty and United Heritage. Texas Specialty is obviously in Texas, Idaho, United Heritage from Idaho. Those courts, appellate courts, have tackled and grappled with this question, and they have unquestionably found that where an insured receives an offer to renew but does not take any action, the policy lapses on its expiration
Do they have the
date,
same
and the
statute
insurer is
we
not
have?
required to mail a notice of non-renewal.
But does Texas have the same insurance code that we have that says a written notice of non-renewal must be sent?
Respectfully, I think that that statute applies only if the insurer.
I understand that's what I'm asking. My question is, does Texas have a similar statute? I don't believe it does.
I'm not aware, Your Honor.
Counsel, even under your theory, your approach here, contract law, the offeree, you would agree, has to receive the offer and either fail to act or decline to accept the offer. Is that fair?
That is fair, Your Honor.
Do we have undisputed facts in this record in that regard? The reply brief points out a number of instances in which the plaintiff disputes facts that relate to what the insured knew or didn't know.
I believe there are several disputes of fact regarding what happened after the insured's agent informed them that there was a renewal quote. I don't believe that that's relevant to the issue in this case.
Because the insurer only has to notify the agent?
No, I think there has to be some notice to the insured, and that was done through the insured's own agent.
So why isn't it relevant? Why aren't those facts relevant?
Oh, I may have not been clear. I meant the facts after the insured received the notice of the renewal quote aren't relevant to this issue. Judge Archer found that everything after that point wasn't a material fact in dispute. It is undisputed that the insured in this case received notice of the renewal quote. It's undisputed that the insured didn't act on it, and it's undisputed that there was no premium paid for and that the policy expired by its own terms. She found that those were the material facts not in dispute, and I would wholeheartedly agree with that.
I'm struggling to understand why, in this case, the insurer, from your perspective, made an offer. The insured did not accept it, right, to renew the policy?
Yes, Your
Honor. And then along comes the natural expiration date. There's no question your client didn't cancel the policy, right?
Yes, Chief Justice.
But at the end, at the natural expiration date, your client did not renew the policy, did it?
There was no obligation to do so. They
I
did
didn't
not.
say whether there was an obligation. They didn't renew it at the end of the policy term, correct?
That's correct, and that
And
brings
how
up,
is that not the plain term of that's non-renewal? It wasn't renewed.
because that's
It
not,
doesn't seem to the statute to say why it wasn't renewed.
well, that's, I'd agree with that. I mean, that's, the point of the non-renewal provision is in the instance of an insured deciding not to renew.
I think, just to follow up on what the chief said, there's no question about the fact the insurer did not continue coverage after the termination date. That's a fact. As I interpret the statute here, you've invoked contract law, general contract law. The contract with finite dates on it, it terminates at the end. But this appears to be a statute in abrogation of the common law, and I think Justice Lopez's question dealt with that. My question to you is, non-renewal is defined as a very clear circumstance, termination of the policy at its expiration date. So if I substitute that definition up into 2009A, it would say cancellation and termination of a policy at its expiration date shall not be effective unless received by the insured. So by punching in that definition with the word non-renewal in the statute there basically supports what Mr. Ferguson's arguing, which is this thing says you've got to send that notice in any event if you want to discontinue your coverage after that date. And that appears to be fairly clear. That what happened here was the notice didn't go out, and by statute, termination of policy at its expiration date is not effective unless notice is received ahead of time. It's, you know, it's kind of a hard-nosed rule for the carrier, but this is a statute in abrogation of common law and also consumer protection. Your response on that, am I reading that too literally or not?
I think you are reading that too literally, respectfully. And I think, again, it applies only in the instance of an insured deciding not to renew the policy. And for the reasons that you brought up during questioning of the appellant, forcing an obligation on an insurer to alert an insured who either doesn't act on a renewal or decides not to do it is illogical, raises questions about when an insurer would ever do that. An insured, as we point out in our brief, an insured could just decide to remain silent and then get another 30 days of coverage just by remaining silent after the expiration of the terms. To take it to the extreme.
Thank you, counsel. I would note that the red light is on.
Thank you. Thank you, Your Honors.
Attorney Ferguson, you reserve 3 minutes for rebuttal.
Yes, thank you, Your Honor. I really don't have much to add. I'm prepared to stand by our brief. I guess I would like to comment on what relief we're asking from the court here. We're obviously asking that the court reverse Justice Archer's decision, but we're also asking the court to remand for entry of partial summary judgment on behalf of Catherine Dudley, because there's no dispute concerning the injury to her when it happened, that Hudson had notice of the underlying suit against its insureds and refused to defend it, and the judgment entered.
Thank you.
Thank you.
Thank you, counsel, for the argument here this afternoon. As is our usual practice, we will be taking the matter under advisement. We'll issue a written decision in due course. Mr. Henriksen, I understand this is your first appearance in front of this court, although it looks like you've been a member of the bar for almost 20 years. What took you so long?
Winning all your cases?
Well, it is our custom, and we invite counsel back to take the personal greetings of the court, which is our custom. Thank you. And good afternoon, you can be seated. The matter before the court is Hancock 125, State of Maine versus Jason Follette, or Follette, I'm not sure which it is. And we are being streamed on the web, both by audio and with video. I would ask counsel to identify yourselves by saying your names for the record, together with the party you represent, starting with the appellant.
Good afternoon, Donald Brown for Jason Follette, the appellant.
Good afternoon, Justine Berry for the appellee.
Okay. And Attorney Brown, if you're ready to proceed, we'd be happy to hear your argument.
No, may it please the court. The circumstances that bring us to this...
I see that you're on the green light, although this may be an interesting issue. Why is it not interlocutory, and why should we take this where motions to dismiss, other dispositive motions are denied all the time in the trial court, and we don't take them as appeals in both civil and criminal cases?
Because under the three different scenarios by which an interlocutory appeal can be taken, the facts of this case fit into all of those three areas: judicial economy exception, collateral order exception, and the death knell exception.
So why is the denial of the motion to dismiss, or two motions to dismiss really, in this case different than denials of motions to dismiss in other cases, which we clearly have said are interlocutory?
Because in this particular case, there are particular issues of law that would give finality to this case without a final hearing or final trial.
But isn't that always true in a motion to dismiss, or like in a civil case? Think about motions for summary judgment. I mean, what the party is saying is we win as a matter of law. Motion denied. Now you have to go through a trial. I mean, that's happens.
It does happen, and particularly with a civil case, in summary judgment it happens, but in a criminal case, there are more significant issues or more important issues I would submit to the court. In this particular case, the gravamen of the elements that would be litigated at trial are different than the issues under the three exceptions to the judicial economy. An inordinate delay in bringing this matter to trial after the 2002 John Doe complaint is 20 years before Mr. Follette was actually named.
Counsel, are you basically asking us to create a special exception for these kinds of cases? Because I frankly don't see this case fitting in any of the exceptions as they stand. But are you asking us in this particular situation, where it's a long period of time, and these are to create a special exception? And if so, do you have any authority for that? Has that happened in any other jurisdiction?
The answer to your first question is no, and I would submit with all due respect that the facts of this case do fit into one of the three exceptions, and in parts of all three of the judicial economy, collateral order, and death knell exceptions.
Well, how does it fit into the death knell exception?
If this court determines that the case should be dismissed, it's the end of the case.
I understand that. If we say, but isn't the death knell exception, the idea being that if we do not hear it, rights are irretrievably lost?
And I think that's the case here. They're irretrievably lost. Mr. Follette was charged by name in 2022, and he's been under the burden of facing these charges, the public scrutiny, and the bail conditions since 2022.
What you're saying is that should happen in any speedy trial argument. Anytime we deny a speedy trial argument at the trial level, you're saying that's death knell?
No.
Because that's not the law. I mean, generally speaking, in the, elsewhere, speedy trial does not give you a basis for an interlocutory appeal.
What's different here is the underlying facts that bring us here, the fact that the statute of limitations was extended.
Generally speaking, a statute of limitations denial does not get you an interlocutory appeal, and we've said that multiple times in civil actions.
In addition to that, Mr. Follette has not been able to exercise his right to a speedy trial. On the one hand, the complaint was filed in...
Counsel, this actually delays trial, right? I mean, I understand you're saying that you should win, but there's public rights to speedy trial. Taking a case sort of on an interlocutory matter has the opposite effect of what you're seeking, which is a speedy trial.
One could argue, as the state has, that any motion which delays trial whatsoever does delay a defendant's right to a speedy trial, but one has to balance those rights to file those motions and to avail himself of all the constitutional protections with the balance of a right to a speedy trial.
But this kind of circles us back to the Chief's first question was, under the death knell exception, he must demonstrate an irreparable loss of a right. So you've run speedy trial right up the flagpole. But what other right does he lose by the fact that the matter proceeds to an interlocutory?
I.e., why is it not fixable after the fact?
He can never have the rights that he's lost during the pendency of this case
Okay,
restored.
I'm asking you for an itemized list of the rights, a bullet point list of the rights that he would lose if we require him to go the distance. What rights does he lose?
He would continue to lose the rights he has that he is restricted by under bail conditions.
There's some bail conditions.
He would lose the right to have this court decide before he goes through a public trial as to whether or not the delay in bringing him to trial, both because of the extension of the statute of limitations.
I mean, you have a motion on a speedy trial, which, if addressed, would reach that. But in the meantime, he is out on bail, and other than bail conditions, his life is pretty much the same going forward. I realize he doesn't like the fact that he's been charged, but what right would he lose in the meantime? And so far as heard you say, bail conditions.
Well, I would respectfully disagree that his life just goes on. He does have those bail conditions, but he's also facing the public scrutiny of this trial. And once again, it's the statute of limitations in the speedy trial that need to be corrected. That's different than other cases where speedy trial rights, a right to a speedy trial is denied.
How is it different? How is it different? How is it different?
Because of the elements, this had a 6-year statute of limitation, which would have expired in 2002. The complaint was filed 9 days before that. That triggered...
No, I understand that, but so it's different not in kind, but in duration? I mean, any defendant who's claiming seeking to dismiss a case for on speedy trial grounds is claiming that there's an undue delay.
And that's true, and oftentimes there is an undue delay, but in our research, we were not able to find anything of the magnitude. I mean, these allegations...
This goes back to what I had asked you earlier. Are you asking us to make a special exception, to carve out a separate exception for cases like this?
No, and I answered that before. I think this fits into the judicial economy. It fits into the collateral order. The issues on appeal are distinct from the gravamen of the litigation. It's an issue of major unsettled issue of law, and there are irreparable loss of rights, which falls into also the death knell, where the substantial constitutional rights are at issue, and those being the tolling of the statute of limitation and the right to a speedy trial.
The difference between the usual statute of limitations case where there's no interlocutory appeal and the usual speedy trial case where there's no interlocutory appeal is that this has an interesting, unaddressed legal question. But that doesn't give you an interlocutory appeal by itself, does it?
Well, I'm certainly hoping that it does, based on the
That's
elements.
fair.
Good answer, fair answer.
Based on the elements that, as I've tried to set forth in our brief and regarding the judicial economy, collateral estoppel, and death knell.
Let me ask it maybe a slightly different way and see if I can get at it this way. Do you agree, we've said that ordinarily, an appeal of a denial of a motion to dismiss on statute of limitations ground is interlocutory and not immediately appealable?
Yes.
Do you agree that we have said that an appeal of a denial of a motion for a speedy trial ordinarily is interlocutory and not appealable?
I agree. The case law is clear.
So tell me what the holding would be in this case as to why you think this is. Give me a one-sentence holding as to why we would take this case if we have said that both of the kinds of motions that are being appealed here are not immediately appealable.
But to tie this in with Justice Douglas's question, I'm not asking for an exception, but I think the facts of this case are exceptional in that we're talking about a 29-year period of delay since the allegations, 20-year period of delay from the time the complaint was filed, and really the crux of it is the
So is it simply the length of time, or is it the interplay of the two that you think makes it worthy of putting it in a one-sentence holding as to why we took this case and we don't take others?
I'd say both, but the real bigger issue, which would be the third issue, is if the complaint filed in 2002 was sufficient to toll the statute of limitations, then the filing of that complaint would also be triggering event for the right to a speedy trial. And I've been not able to find a case anywhere where those two things lined up the way they do in this case, and 20 years after the complaint was filed, which is really 28 years, if my math is right, 26 years after the allegations, a man is formally charged by name when he hadn't been before, which brings me to the point he couldn't ask for a speedy trial any sooner because he didn't know. So I don't think I'm asking for an exception, Justice Douglas and Chief Justice Stanfield, but I think the facts of this case are so exceptional that they fit into really parts of all three of these exceptions to warrant an interlocutory appeal.
So with the minute and 19 seconds, let's get to the merits. If we do entertain this, why shouldn't we go with the majority and say the DNA profile was good enough and for tolling the statute of limitations?
Because I think it's the legislature's, with all due respect, place to define what the statute of limitations should be. In fact, in this case, at the time of the allegations, the statute of limitations was 6 years. Since then, I think in 2019, the Maine legislature increased that period of time to 20 years. So even if the 20-year statute had been in place in 2002 or 1996, or if it was retroactive, this statute of limitations would still have expired in 2016, 6 years before Mr. Follette was formally charged, 9 years ago now. So I think those are the reasons that this is different and an exception.
You have 16 seconds.
Even I can't say much in 16 seconds. Thank you very much.
Thank you, counsel. Attorney Barry.
Thank you. Good afternoon, and may it please the court. In the summer of 1996, Shannon Moore was sexually assaulted in her apartment, where DNA evidence from an unknown male was recovered from that crime scene. Soon after, in October of that year, Shannon Moore's neighbor, Amy King, reported that someone had burglarized her vehicle and had ejaculated onto her steering wheel. The semen taken from both crime scenes proved to be from the same suspect. As the 6-year statute of limitations was about to expire in 2002, law enforcement obtained a John Doe No. 1 arrest warrant identifying the suspect by his DNA. Throughout the years, law enforcement diligently pursued leads to no avail. In 2022, through genealogy testing, investigators received a lead to investigate the Follette brothers. After Jason Follette's DNA was obtained through a search warrant, forensics confirmed that Jason Follette's DNA matched the same DNA recovered from Shannon Moore and Amy King crime scenes. During that time, the district attorney's office immediately amended the complaint to include Jason Follette's name and physical characteristics. The state contends that the interlocutory appeal does not fit into any of the exceptions to the final judgment rule, as Follette has not demonstrated irreparable harm or loss of any substantial rights. Regarding the statute of limitation, the state maintains that the John Doe warrant with DNA identification was sufficient to toll the limitations period, citing numerous jurisdictions that have upheld similar DNA warrants. The state further argues that Follette's speedy trial rights were not violated under the Barker versus Wingo test, since he has remained free for 27 years while law enforcement diligently pursued leads, and any recent delays are solely attributable to Follette's own numerous motions and motions to continue. The state requests that this honorable court dismiss Follette's appeal and allow the prosecution to proceed based on the valid John Doe warrant that identified him with reasonable certainty through his unique DNA profile. I can open it up for questions.
I just want a point of clarification. You've indicated that you think none of the exceptions apply, so it's the state's position that we shouldn't entertain this interlocutory appeal. Well, in your brief, you said the law court might use the judicial economy. So which would you prefer?
I would prefer that the law court not entertain the interlocutory appeal. I did say might use because that was the only area that I could see that this is a novel idea that's going on in Maine, and Maine hasn't heard it yet.
As we know, with DNA evidence, the analysis focuses on certain, some say loci, some say loci. What do you say?
I call it loci.
Loci, all right, we'll go with loci. With specific loci, but the more matches, more loci that are revealed make a stronger case to the point where it's almost presumptive. But if you just get one or two way down at the bottom, maybe not so much. If we reach the merits on this, do we have to opine on how many loci were necessary to adequately create this original warrant 20 years ago?
No, I don't think so, because 20 years ago they were developing profiles on 13 loci. They have since expanded that to 20 loci, and in this matter they have as well. But in previous jurisdictions, prior jurisdictions, when 13 loci were identified, the court said that that was sufficient to identify the perpetrator.
If we were to reach the merits, and this isn't the state's diligence of essentially bringing a named person in, even if the John Doe warrant is okay, for speedy trial purposes, isn't it important to have a full factual record as to the state's diligence in pursuing a named individual on the basis of that DNA?
In the trial court's order denying the motion to dismiss, we did have hearings and did call Detective Stephen Pickering and Detective Stephen McFarland to the stand, who were the chief law enforcement investigators on the matter for pretty much the first 20 years of the case. And they testified that there were clandestine operations where undercover police officer women were dressed in bikinis in the same general area, trying to see if they could lure the defendant out. They also hired a jet or airplane, actually, to try to figure out if there are any inroads that the defendant was using that police couldn't identify. They also made an FBI profile. They discussed the case with Ontario police.
But this technology of using, these registries, whether it's DNA, whether it's 23andMe or whatever, different registries, to essentially backtrack into identifying who a DNA sample belongs to. I mean, this has been in existence for years before it was taken advantage of in this case.
Dr. Middleman, who was a forensic genetic genealogist that testified on the state's behalf, did say that the technology wasn't truly available until 2018, as far as he was concerned.
Which is 4 years before they did it.
Right, 4 years before. Also,
well, for speedy trial analysis, isn't that significant?
The 4 years before, it was also very expensive. So the cost to the state.
Does that matter for speedy trial analysis? Do we care whether it's a burden on the state?
I guess not in that sense. It is still the state's due diligence. However, this is one of the first cases that forensic genetic genealogy has been used, and we did use it, and it was akin to an anonymous tip in order to figure out who could have perpetrated the crimes. But that was after all leads have gone dry. In the meantime, we had exonerated over 40 men through their own DNA. Law enforcement had other cases that they were still investigating this case with, trying to see if there was a correlation, and unfortunately the case just went cold.
So the reasons for the delay are one of 4 factors. Would you agree that as to factor 1, the length of delay weighs in the defendant's favor.
I agree.
Would you agree that factor 3, which is assertion of the right, weighs in the defendant's favor?
I agree. You asserted it twice.
So it really comes down to the question, so that right now it's sort of assuming that the state did act in a diligent fashion. It's still 2-1, so to speak.
It is, but so
So let's talk about factor 4, prejudice. This is a long time. Memories fade, evidence disappears. In fact, one of the principal witnesses here in this situation, I believe the defendant's father, who may have had significant evidence, has passed away. What's your view on how to weigh the prejudice as a factor here?
So on the fourth factor, DNA evidence doesn't erode over time. So that evidence is fresh still. The defendant has never actually given a reason or how his father's testimony would have helped him.
So are you just
in the
saying
underlying
because it's
case.
DNA and the rest of it doesn't matter because it wouldn't have a defense anyway? I mean, is that what you're saying?
No, I'm not saying that. I'm saying that the defendant's father passing away, there has been nothing in the lower courts where it was brought to anyone's attention that his testimony would have provided any type of grounds where he could say that, you know, he's been oppressed and hasn't been able to defend himself in this case.
I may be mistaken, but I thought I recall from the record that there was some suggestion that a potential alternative suspect might have been identifiable by the father.
The state doesn't recall that. That was never testified to. There were other leads that they were pursuing where they were asking the victims at the time what the perpetrator looked like, and you know, during the investigation, those were crimes. They were sometimes compared to our crimes. However, they still were never able to identify Follette, and they even put his DNA into CODIS, and it never found a match.
But that's not his problem.
It's not his problem, but he could have asserted his speedy trial rights sooner if he had come forward.
Are you suggesting that a defendant has an obligation to come forward and confess to a crime that he doesn't even know he's been charged with?
No, I'm not saying that. However, if he wanted his speedy trial rights to be asserted at the time that the John Doe complaint and arrest warrant were
But if
issued,
he doesn't
could
know
have.
anything about it, how is he supposed to assert
I
a
agree,
speedy
he doesn't
trial
know because
right?
only his DNA identified him on that complaint. However, there were news articles, there were lots of law enforcement involvement, there were lots of victims in the
But
area.
you really do sound like you're putting it on the defendant that if you don't confess and come forward, then it's your problem that you didn't have a speedy trial. And I don't think that is consistent with our Constitution, state or federal.
Sorry, Your Honor. I don't feel that he should have come forward. However, he can't hide and wait for the statute of limitations to expire. And
Well,
then
was he
use it.
hiding or he just didn't know anything about it?
Well, we just didn't know who he was, but that wasn't not the fault of law enforcement. They were literally tracking down leads. They had just submitted another sample into CODIS in 2022. Before Steve McFarland retired in 2021, he had also submitted another DNA sample to no avail.
To no avail because apparently, this particular, the matching sample, whoever matches the sample, wasn't committing crimes.
He may not have been committing crimes or crimes that he could get caught for.
Can I take you back to the four factors that Justice Douglas was referring to? With respect to you talked about the cost that initially in 2018 when the DNA technology had been improved. Is that something that's beyond the responsibility of the state or being held, the state being held accountable as to the result of that being so expensive to implement at that point?
So there is a DOJ intern policy that was established in 2019 that just gives guidance. It's really something that the only thing that law enforcement can use for forensic genetic genealogy until something else comes about. And part of that guidance is to contact the district attorney's office and reach a mutual agreement on whether forensic genetic genealogy can be used and then decide who's going to pay for it. And that happened in this instance, and the forensic genetic genealogy costs around $7,000 to get this one done, to get And it didn't even identify the defendant. All it did was give something similar to an anonymous tip that said, hey, you should work to exclude these 3 brothers. So depending on what the state is willing to bear the cost of, because it is expensive, I think it should be on a case-by-case basis, since there is no real guidelines that establish us outside the DOJ interim policy.
In any event, with respect to that factor, the trial judge did make a finding that the state investigators had remained active and were diligent. And so for our purposes on appeal, we are looking at the trial judge's findings, are we not? And if there's evidence in the record to support those findings, doesn't that support that factor for the state? Yes.
Can you say that in another?
Well, the trial judge made specific findings as to factor 2, that the investigation had remained active during this period, that the state did not delay, that the investigators did not delay, that they were diligent in conducting the investigation, and I think concluded, or at least found facts that we would have to review on a clearly erroneous standard, and only depart from if there's no competent evidence to support the trial judge's findings.
I feel that the testimony from the witnesses that stated all of their due diligence on the record, I think that you should uphold the trial court's rulings that the reason for delay was not attributable to the state.
So you're saying there was evidence and therefore it didn't clearly compel us to conclude that it's clearly erroneous? It's a softball.
That's a softball. The answer is yes.
Sorry.
Can I ask you about the statute of limitations? What, in the state's view, is the purpose of the requirement that a complaint or indictment identify with particularity the defendant? What purpose is that serving, in your view?
I think that it lets the accused be formally charged, and they know that they're formally charged within the community and societal standards.
So let me ask, does DNA, a sequence of numbers, DNA, that, I assume you would agree, does not let a person know that he or she's been formally charged? Absent specialized knowledge and equipment, you would never know that DNA applied to you, right?
I agree with that. However, DNA is your biological identifier, and there are other things that change over time. You could actually change your name. You could change your hair color. Your weight can change. Your
Yes,
eye
but if
color
I
can
change any of those things, I also know what it used to be.
That's correct. Well, we're asking that the court know that that DNA identified the defendant. We're not asking that the defendant knows if the DNA identified him.
So you don't think the particularity requirement is intended to protect or provide notice to a defendant who's charged? It's just to provide information to the court?
No, I think the particularity requirement is important. However, in this situation, it was used as a preservation tool to toll the statute of limitations in this matter.
Thank you, counsel.
Thank you.
And Attorney Brown, you reserve 3 minutes.
Justice Douglas, I couldn't think of the case when you asked me the question, but under judicial economy, Cutting versus Down East Ortho Association talked about the judicial economy exception is invoked when there are particularly unique circumstances in the history of a case, such as exceedingly long litigation, multiple pending proceedings involving the same party. While that was a civil case and this is a criminal case, I think that even though the litigation began in '22, the complaint goes back to 2020. So I think this case fits into the judicial economy in part under that case.
Why would the father's evidence be so important to this case, defense?
For at least 2 reasons, one of which the DNA in this case, Mr. Follette, the deceased Follette, Jason Follette's dad, was not a biological Follette. And we, since this case has arisen, had many questions about their ancestry and who he was, and hence what my client Jason's biological ancestry is, and we haven't been able to find out anything because he's dead. Secondly, and perhaps more importantly, is the police conducted a tracking with a dog as a result of some incident that they claim was in connection with this case, and the dog track went to Stephen Follette's house, my client's dad's house, and there was conversations between law enforcement, Mr. Follette Sr. and his wife, and while my client was generally aware that happened, had some discussions with his dad. We can't talk to his dad. I can't talk to him. He died in 2018. Unfortunately, his widow is suffering from dementia.
So it sounds like what you're saying is that in order to really understand the extent of the prejudice on account of the delay to the defendant, we need to have a trial. And if there's a bunch of people that say, if people say, you know, I don't remember, it was so long ago, or no, we didn't, but, you know, it's too long, we can't do that, then that's going to enhance the case that you would have for prejudice, wouldn't it?
Perhaps, but I think the more important issue is a trial for my client that's fair. The absence of those witnesses is going to make it difficult for him to have that fair trial.
Can I ask you, just in the short time you have remaining, what would be the purpose of introducing that testimony? Are you trying to impeach the DNA result? I mean, DNA, the Massachusetts court says, it's an indelible barcode that identifies with irrefutable precision. Are you trying to undercut the powerful DNA evidence with these anecdotes of things that occurred back in the day?
I'm not really sure because I can't talk to Stephen Follette about the search that occurred at his house and any evidence that was taken on that day and who it might have belonged to. So I don't know the answer to that.
Thank you, counsel.
Thank you.
Consistent with our normal procedure, we will be taking this matter under advisement and issuing a written decision. Attorney Barry, I understand this is your first appearance in front of this court, and our custom is to invite counsel back to take the greetings of the court. So we would be happy to see you back in the conference room. And with that, I believe we are in recess in this matter.
All rise. All persons having anything further to before the Honorable Justices of the Supreme Judicial Court sitting in the law court in Kensington Park, due to their attendance here at 9:50 tomorrow morning, as this court now stands adjourned. God save the state of Maine and this honorable